Welcome. Today we're going to be covering the Guide to Computer Forensics Investigations. This is the 6th edition. The material all comes from Cengage. They own and control all copyright material. I'm just providing video lectures on the individual chapters for my courses using this textbook. My name is Arthur Salmon, and I'm going to be working with you throughout this book. Thank you. Chapter 15, Expert Testimony in Digital Forensics. In this chapter, we are looking at explaining the guidelines for giving testimony, more specifically as a fact witness or an expert witness, describing guidelines for testifying in court, explain the guidelines for depositions and hearings, and describe the procedures for preparing digital evidence for testimony. This is all gearing towards on the public side, dealing with law enforcement and the court system. And again, these are our lecture reviews. The lab component we are doing in separate videos. So let's go ahead and jump on in. So let's look at what we're going to be doing for preparing for a testimony. Either you're going to fall as a fact witness or an expert witness. A fact witness provides facts that they have found during an investigation. They explain the evidence, they explain the process, and how it was obtained. They do not offer a conclusion, they only state a fact. An expert witness, however, is more based off of their opinion, based off of observation. The main difference between a fact witness and an expert witness is the expert witness is classified as an expert. Their opinion is because of their experience, their training, their skill, their resume. Opinions are formed from their past deductive reasonings, past experience, and all of their work. So their conclusions are often viewed as factual. Because when they are making an opinion, they're going to be doing that based off of the facts that are reviewed through the actual analysis of the forensics investigator. The opinions can also can come from observation, not necessarily them completing the work. So if an analyst completes a work, writes a report, the expert witness can review and then make their opinion based off of the findings of the report. The expert witness does not have to conclude or conduct the investigation themselves. Regardless of the type of testimony, there are some very specific requirements. Normally establish communication early with the general counsel or attorney. You're going to be learning about the process, the victim, the complaint, the opposing experts or factual witnesses, as well as the opposing attorney. Oftentimes the opposing attorney is going to try to discredit the fact witness or expert witness, or they may bring in their own fact witnesses and expert witnesses to rebuke what you have concluded. So you do need to understand the basic points of dispute. You need to keep notes and more of a rough draft and record only factual information. You do want to keep opinions to a minimum unless you are an expert witness, and in that case you're going to be outlining what factual data led you to your opinion. Throughout the process, one thing has remained clear: documentation of the process so that you can use it to write your report. You need to confirm your findings through the documentation. You need to be able to reproduce your findings through your report, and all of that is done through documentation. As you acquire data, as you acquire factual evidence, the process that you are doing will be documented. You need to write down the steps. That way, you can actually be able to write your report and give it to opposing counsel, and their factual individuals or even members of your own team should be able to take your report and following the same steps, same general guidelines, and do the same analysis and get the same results. When you're doing your overall preparation for your testimony, you need to consider some of the main questions. What is your role or your story in the case? What can you say with certainty or confidence? What is the client's overall theory of the case? And And again, your role is to present factual information, so your conclusion may not coincide with what the attorney is wanting. So again, you need to understand where that role is. Does your opinion fit into the theory of the case? Are you going to supply information that is vital to your side? What is the scope? Did you follow the appropriate scope? Did you keep it within the boundaries of what you were supposed to do? Have you identified the client's need for how the testimony will fit into the overall function of the case? And again, that really is all dependent on the type of case and what your role is in that case. It's going to be reiterated over and over again. Document every single step. You need to prove that your analysis is repeatable, that your conclusions, if done the acquisition again, you could produce the same results, and someone else can produce the same results within reason. You need to validate your tools and your methods, and all of that needs to be documented. Do not use a formalized checklist. Do not include checklists in the final report. Oftentimes, the opposing side will challenge the checklist because there may be portions missed or portions that aren't included in the checklist that you, the analyst, just automatically do. So we have to be very careful with checklists. You do want to collect evidence, and you want to document every single step and every single tool and every single version of each tool as you go through the process. This will also include maintaining the chain of custody from when the evidence was collected at whatever incident scene or crime scene all the way through the analysis, all the way through the court case and the court hearings. Failure to provide appropriate chain of custody might mean that evidence is thrown out of court. But you also need to keep in mind what you are allowed to capture and your scope. It doesn't need to be overly broad, it needs to be more focused and narrowed. So that means collecting the right information, only collecting what you were authorized to collect. If you collect information that was outside of bounds, essentially, that could be a detriment. Note the appropriate dates and times of the workstation. Document the entire step, and that includes dates, times, when you are working on what. All of that is important. Keep only successful output. You do not need to keep previous runs, though you should document kind of previous steps so that you know what worked and what did not work. Things that did not end up panning out, or things that did not work, you don't need to produce that as a final report, but you can keep that for internal records. That way, as you're working through the investigation, you can see what you've already tried. Search for keywords using well-defined parameters based off of the scope of function that you are working on. You do want to make sure that you are being thorough in your documentation, but some places do require notes to be kind of simple and easy to follow. List relevant evidence and list kind of dates and times that you're working on what evidence. When you're working with your report, you only want to focus on relevant information, relevant evidence. No one cares that you worked on a piece of an artifact that didn't pan out. They're wanting to focus on what was successful. You need to define any procedures you use to conduct your analysis as an appropriate methodology. Confirm with your professional standards so that you know what are the approved methodologies. List any references that you may have used in your investigation, and so forth. Do not record conversations or telephone calls. That's a big one. There are federal information requirements. There are other cases in which you may have testified as a witness within the appropriate time frame. You may need to list those out. Normally last 4 years for expert witnessing, 10 years of published writing, and any type of compensation for testifying. That way, the court can validate who you are and that there is no conflict of interest. Brief your attorney on findings and opinions of the court's experts. You need to be mindful that when you are working as an expert, either consultant or witness, that you are working in tandem with the appropriate attorney. How can you be classified as an expert? That's a big thing, is if you're a consulting expert or an expert witness, what makes you an expert? You have to have a CV. You need to be able to show your training, your education, your experience, what qualifies you as the expert. You want to show continuous enhancement of your skills. You want to detail very specific accomplishments. You want to see what you've done. And if you've had any testimony or you have worked as an expert witness, all of that needs to be logged and included. That way the court can see that you are indeed an expert in your field. One of the concerns with dealing with experts are language barriers. So sometimes having technical definitions, that way you can run through them and you can actually be able to break them down. Prepare definitions of technical concepts. You do want to make sure you can use your own words, your own language, and you're wanting to remove the jargon application. You want to be able to speak in plain English what certain core concepts mean. Examples of definitions prepare ahead of time: hashing, file slack, timestamps, logs, things of that nature, so that you have a easy, digestible definition. Folders, directories, hardware, software, operating system, things like that are a little bit more complex of a topic that the average person would not know. We also need to be prepared to deal with news media. Some legal actions that do generate some interest from the news media, so you need to work with your general counsel or your team to make sure that you're following all of the appropriate policies. Reasons to avoid any type of interaction with media: comments could harm your case, no control over context, and you can't rely on journalists' promise of confidentiality when making statements. Normally at this point I say if you are an expert witness and you're doing it on behalf of an organization, you want to work with your organization to understand the role that you may have, and if there are any agreements that you may have with the organization or policies or procedures when dealing with the media as a representative of your organization. If you are an independent individual, then you'd be working with your general counsel to do the exact same thing. Is what are the rules, what are the roles, what are the regulations dealing with your party and the news outlets. You're going to notice the common theme is you're going to be working with your team regardless. Even when you're testifying in court, your attorney is going to be present. You're going to have opposing attorney also. They're going to try to discredit you typically, or they might bring in their own expert witness that will try to discredit you. It's a game. The big thing is understand that both sides can ask you questions, and they're there to trip you up. They're there to see if they can get your findings removed. Your attorney might have the opportunity for redirection, but it really just depends. You could be called later as a rebuttal or a repeat witness. So understanding your role inside the overall structure is kind of important. What part do you play on your team as it relates to the presentation of facts in the court case? Understand the actual trial process. There's a specific order of trial. Normally there's a motion to impanel the jury, opening statements, plaintiffs, defenses, rebuttals, arguments, and then the jury has their portion of instructions that will come to a conclusion. Those are the general guidelines for a trial. You as the witness need to be able to produce qualifications. If you are an expert witness, then you need to be able to present that. Voir dire is basically the qualification that will demonstrate you as an expert witness. The attorney will ask the court to accept you as an expert, and if the court agrees, then you'll be coded as an expert. Opposing attorney might try to disqualify you depending on experience, skills, CV, or a number of other disqualifying components. So general guidelines for testifying: you have to be professional, you have to be polite, you have to be shown to be credible, you have to have a certain level of trustability, you need to be conscious of both the jury, the judge, the attorneys, the parties at play. If asked something, you cannot just say yes or no. You need to be able to understand that your responses matter. You cannot answer, "That's beyond the scope of my expertise," or "It was not part of my investigation." Those are not appropriate responses. Avoid overstating opinions. You do want to make sure that the facts that you've actually analyzed are what form that opinion. You want to have guidelines for delivery and presentation, in acknowledgement that the jury and directing your testimony to that presentation. Oftentimes, when I've presented as an expert witness, I've been allowed to do a presentation. So the attorney would do their presentation, and I would then answer questions based off of that presentation as we went through the presentation line by line or screen by screen. Part of the presentation might be you presenting it. So guidelines might cover movement, turning towards the questionnaire when asked a question, turning back to the jury when answering, microphones that are appropriately placed, avoid humor, build the rapport, build the reputation within your explanations. Use simple, direct language so that your audience can understand you. Use a chronological order to describe events. Be methodical. If you're using technical terms, identify and define them. Cite any appropriate resources as necessary, and make sure your chair height is comfortable so that you can turn and face the jury when answering. You're presenting factual information, so you need to be believable, and if you are uncomfortable or if your back is to the jury, that makes it a little bit harder to do. Dress in an appropriate manner. Don't memorize your testimony, but you should be very familiar with it. For direct examination, state your opinion, identify evidence that supports your opinion, explain the method you used, restate your opinion. You always start and stop with your opinion. Preparing your testimony with the attorney that hired you. Again, on your team, your attorney has their goal. You need to see how you are working with them. How is the data or the evidence stored? What images of the captured drive, how is that done? How is the recovery of any contents relevant? What are the processes? Work with your attorney to develop the script that you're going to use to present to the court. This, again, is not done on the fly. This is practiced, reviewed, practiced again, reviewed, and so forth. Another big thing is the ability to use graphics. We, people, are graphical people, so having just a bunch of text doesn't really help. So graphic exhibits do help to illustrate and to clarify findings. Your exhibits must be clear and really easy to understand. You don't want information overload. The graphics should be big, bold, and as simple as possible. The goal is to make the jury receive information that is important. Review all the graphics with your attorney before trial and adjust as appropriate. Avoid testimony problems is another big guideline. Recognize when a conflict of interest does occur. Conflicting out basically is when you have an attempt by an opposing attorney to prevent you from serving on an important case. And there's a lot of different rules and regulations why this might occur. So again, just keep that in mind. Work with your attorney to make sure everything is in order. Avoid agreeing to review a case unless you're under contract. Avoid conversations with opposing attorneys. You should always receive payment before testifying. You don't want to do payment post testifying because there are some very weird clauses that come along with that. Don't talk to anyone during court recess. If a jury approaches you, you just stop. No talking, period. Make sure you conduct any conferences with the attorney in a private setting. Understand rights to privacy or expected right to privacy. You having a conversation in a hallway, there is no expected right to privacy in that setting. You having a conversation in a closed room or a sealed room, there is an expected right to privacy there, so make sure you understand where you are at in reference to the type of communication that you should be having. One of the last big concepts you need to understand is understanding prosecutorial misconduct. If you've found evidence, exculpatory type evidence, you have an obligation to ensure that the evidence is not concealed. Initially, you should report the evidence to the appropriate prosecutor handling the case, but be sure the documentation is clear for the communication. You're not just doing it willy-nilly. You want to make sure that you're following the appropriate policies and procedures. If this information isn't disclosed to the defense attorney in a reasonable amount of time, you can report the prosecutor to the supervisor or to the judge. You can always escalate as necessary. There is a procedure for evidence that needs to be adhered to. And again, you as the expert witness, you as an analyst, you as a consultant are not expected to know the law. That is why you having both a personal attorney and working with the attorney on the case is crucial. So what about when you're testifying during a direct examination? There are a number of techniques that you can do. Work with your attorney to get the appropriate language. Be aware of the inclinations to be helpful. You want to review the examination plan that was prepared. You maybe not memorize, but you want to at least go through them so that you know kind of what you should be saying. Provide a clear overview of your opinion, the facts that helped shape that opinion, and again, always end with your opinion. Use a systematic, easy-to-follow plan describing what you did, your methodology. Practice. Practice again. Use your own words when answering questions. Practice again. Language is important. That's why practicing the testimony is equally important. Make sure you understand some very key terms. Independent recollection, customary practice, documentation of the case. These are three areas that you're going to have to work within. You want to present your qualifications, what defines you as an expert witness. Avoid any type of vagueness. You want to be direct. You want to be able to talk in a direct manner. When you're using graphics, make sure that the jury understands the explanation. You want to be concise, but at the same time, you also want to make sure that you're defining it simple enough for the average person to be able to understand. Avoid using jargon, and if you have to use technical terms, again, define them first. Use your own words. What about when you're dealing with a cross-examination? Recommendations are, again, use your own words. Keep in mind that certain words have additional meaning, so be careful of the duality of language. Be aware of leading questions. Never assume, never guess. You want to make sure that the answers you are given are based in fact or through your experience. Be prepared for challenging, pre-constructed questions that the attorney has then practiced. Did you use more than one tool? Did you use more than one variation of tool? What were the variations of tools? What were the versions of tools? Be mindful of rapid fire questions. Question. A lot of the times, these are strategies used to trip up to disqualify a witness. Sometimes the opposing counsel will declare that you aren't answering the questions so they can treat you accordingly. Keep eye contact and keep your presentation towards the jury. Sometimes The attorney will ask several questions inside a single question, so be mindful of your responses. One thing to understand is, especially when the attorney is speaking, sometimes they'll do long-winded speeches and they'll phrase them as questions to get their point across. So be mindful that an attorney may also try to put their words in your mouth. That is why you need to practice your testimony, you need to be patient, and you need to be able to respond with an factual opinion. When you say ABC, you need to be able to justify why ABC. Most jurisdictions now allow the judge and jurors to ask follow-up questions. Avoid feeling stressed and losing control. Be patient, take a deep breath, and respond appropriately. Never have unrealistic high self-expectations when testifying. Everyone makes mistakes, but it's being able to own up to them that is important. What are some things you should avoid? Avoid being argumentative, having poor listening skills, or using more defensive, closed-off body language. Nonverbal cues are equally important. Being too talkative or talking too fast. You want to have a good pace. Being too technical for your audience. If you're overly technical, the jury's not going to understand. Act surprised or unprepared to respond when presenting with unknown or new information. You want to be able to present an expert opinion. Again, you are an expert witness, so being surprised or unprepared makes you be deemed, or makes you view, from the jury's standpoint, not an expert. We also have some hearing definitions. So depositions differ from a trial testimony. There's no judge, there is no jury. The opposing attorney will preview your testimony at trial. There's also a discovery deposition. That's part of the discovery process for a trial. There's also the testimony preservation deposition. This could be requested by the client, and it preserves your testimony in case of a scheduled conflict or health concern. Some courts will allow this to be presented in lieu of you having to actually testify in court. Recommendations include staying calm, relaxed, confident, maintain your professional level of demeanor. Again, understand your nonverbal cues. Use the names when answering questions. Again, be courteous, be kind, be respectful. You can also be assertive in your responses, but again, still being professional and being polite. Use facts to describe your opinion. You can state your opinion, but you also need to include the facts that shape that opinion. Being deposed in a discovery deposition is more of an unnatural process, but is part of the process nonetheless. Some other additional areas that you need to be mindful of is if you prepare a written report, opposing counsel might try to use it against you. That is why the reports need to be verified and gone through with a fine-tooth comb. The reports need to be very specific. If your attorney objects to a question from the opposing counsel, they'll say so. Pause and think of what direction your attorney might want to go with your answer. Again, you're supposed to be working with your team, but you're also supposed to be presenting factual information. Be prepared at the end of a deposition to spell any specialized or technical words that you used. You want to have definitions for any key technical or highly specialized words already ready to be gone through just in case. Again, you want to avoid any specialized or technical words, but sometimes that's not the case. And some of these, this is an overview. You're not going to be in this type of situation unless you are an expert in your area. But you do need to recognize deposition problems, discuss any problems before the deposition, identify any negative aspects and kind of ways that they may be countered. Be prepared to defend yourself and your opinion. Avoid omitting any information. Avoid lying. Having the attorney box you into a corner isn't a good thing. You also want to avoid any type of contradictions. Again, you are the expert. You need to conduct yourself accordingly. Be professional, be polite, give your opinion, but Also be mindful that they might have an opposing expert that is trying to debunk what you are saying. Again, understand your body language, understand your demeanor. All of those are equally important. It shouldn't have to be said, but it is still equally important. Don't lie. To respond to a difficult question that could jeopardize your client's case, pause, think, process, answer. Don't lie, but there's nothing wrong with giving an appropriate amount of time for you to formulate a response. Keep in mind that you can correct any minor errors during your examination, but you will have to actually state that you made a minor error, so keep that in mind as well. Discovery depositions, testimonies, often don't make it to the jury. It might be presented to the jury, but oftentimes they're discredited, so they're not normally viewed. Testifying at a hearing is generally comparable to testifying at a trial. They're going to be very similar. A hearing can be an administrative agency, a legislative body, or even a court. It doesn't necessarily have to be within the legal system. There's often an administrative or legislative hearing related to specific events that result from litigation. A judicial hearing is a court hearing, and that is determining the admissibility of a certain amount of evidence or motion before a trial. A judicial hearing, no jury is present. It is normally the lawyers and the judge. Can you prepare for forensics evidence? Sure. In our book, we've used autopsy for Windows to extract email, for example. Here's an example. You can see what data has been extracted. There is also an Excel spreadsheet from an email that was extracted. Part of this is you'd prepare this type of collection analysis for your testimony. You work through the problem and you prepare for your testimony. That means you should be prepared to answer questions about what you did, what steps, what tools, what versions, how did you analyze it. You might also be asked to specifically explain specific features. Explain how the applications work and how the digital forensics tools work. You need to understand how to be able to communicate about the tools and the software you are using. And again, this is normally done as an expert witness, so the entry-level analyst isn't necessarily going to be doing this, but you do need to keep that in mind that this is the goal at the end of an investigation, is to present the data to the appropriate authorities. All right, that is it for this chapter. We talked about when a case goes to trial, what do you do? We talked about if you're called an expert witness, how to prepare your testimony. We also looked at testifying in court. We looked at making sure you're prepared. We looked at both factual witnesses and expert witnesses. We talked about depositions and how that differs from trial. We lastly talked about depositions, discovery depositions versus testimonial depositions. We looked at guidelines for testifying. We looked at kind of general tasks you should do and avoid. And lastly, we talked about making sure you're prepared to answer questions based off of certain level of criteria. Questions or concerns, please feel free to reach out. Thank you. All right, now that we've wrapped up some of the material for this chapter, are there any questions? There's a lot of different material covered, so again, the key thing is, as you're going through the material, whether it be the reading, whether it be the videos, ask questions, write questions down. The more that you can engage your brain in this material, the better you are at retaining the information. So again, questions, please feel free to reach out and we will go from there. Thank you, and I look forward to working with you throughout the remainder of these modules.